All right, my clock says 6 o'clock, so I'd like to call to order this meeting of the Fire Code Board of Appeals for February 1st, 2021. Chris, would you mind doing a roll call?
Yes, sir. Miller?
Here.
Verplank?
Here.
Beckman?
Here.
And Janik?
Here.
All right.
Present.
Thank you. Standard reminder to the board to silence cell phones and put them away for the duration of the meeting. Third is approval of the agenda. Can I please get a motion to approve the agenda as stated?
So moved.
I'll support.
Okay, so we have a motion to approve the agenda to ratify the procedures for public participation and meeting conduct as described in the notice of public meeting via video conference. Chris, can we get a roll call, please?
Yes, sir. Verplank?
Yes.
Beckman?
Yes.
And Miller?
Yes.
3-0 pass.
Thank you. Next is approving the minutes from our January 11th meeting. Okay, get a motion to approve those minutes, please.
I'll make a motion to approve the minutes of January 11.
I'll second.
Okay, any discussion on the minutes? Nope. All right, Chris, can we get a roll call vote, please?
Yes. Beckman?
Yes.
Verplank?
Yes.
And Miller?
Yes.
Motion passes 3-0.
All right, thank you. So now moving into the reason why we're all here, which is the public hearing to consider the appeal of 3487th 66th Street from the applicants Tyler and Josie Bodish. So I'll open the hearing, and the way that this will go is we're allotting up to 15 minutes for both the applicant or the designee and the fire code official or the designee to share a presentation that sort of states their case. They certainly do not need to use that time period, but we're inviting them to. Also, we'll allow for presentation by any other interested parties for a limit of 3 minutes each. We'll have discussion as a board, we'll close the hearing, and then determine action. So we'll start with the presentation by the applicant or their designee. So I'd invite that party to open their mic and get started. I think Mr. Phillips, is that you?
Yes, can you hear me fine?
Yes, thank you.
Okay, thank you. Aaron Phelps on behalf of the applicants, Tyler and Josie Bodish. And I guess that's where I'd like to start, is that weaved throughout this entire process has been the concept of a development, a developer. There have been various discussions that have been ongoing before this process began and since, related to Mr. Van Horn and the fire district. But what is at issue here is one lot, one building applicant, Mr. and Mrs. Bodish. They bought a lot of record in the township. There were no restrictions. That lot is the subject of a land division. 2 years prior, that land division was approved by the township without any further restrictions, any requirements, no requirement that municipal water be extended or anything of the kind. They paid money for that lot. They submitted their building permit application, and the township has confirmed at our last meeting of the Construction Board of Appeals that a building permit would issue, that they're entitled to build on that property, but for this objection from the fire district. And so, you know, the Bodishes don't have any control over all of the other lot owners. They don't have any control over extending municipal water on behalf of any of their neighbors. And they don't have any control over Mr. Van Horn or how he spends his money. And they certainly didn't have any control or involvement in the land division process that gave rise to the creation of their lot, which they purchased. And I think in addressing the narrow issue with that background, I'm going to turn right to the fire district's letter they submitted as part of this proceeding. It's page 31 of the overall packet. And near the top of that, I think we can agree that there isn't a requirement, and that's what's really at the core of this. Is the fire district has taken the position that there is a requirement of water supply, which in its letter to the Bodish's builder indicated it would be fire hydrants and a water main. And that requirement is nowhere found anywhere in the fire code. And it is not a requirement that is imposed by the fire district in any other similar situation. The last sentence of the second paragraph from the fire district says, based on a plain reading of the IFC's terms, nothing restricts the FCO's review authority to larger, quote, developments, close quote, or conversely exempts single-family residences from review of proposed water supplies. Well, that's another way of saying there's no requirement for anything other than what the fire district deems in its discretion should apply, and that simply isn't the law. If you take a look at the stack of other approvals that have been issued by the fire district, they start on page 19 of the aggregate submission. You'll see that the fire district deputy chief Mantels routinely issues letters in response to other building permit applications where he states that approved water supply is, quote, not applicable, paren, single family dwelling exemption, close paren. And that's repeated throughout multiple paragraphs of these letters, paragraphs 13, 14, 15, 16 on page 20, and multiple of these letters. One thing you'll take note of is nowhere is there a citation to single family dwelling exemption. There are citations elsewhere in the letter, but nothing to single family dwelling exemption. That's because there is no exemption in the IFC. And of course, there's no exemption because there's no requirement in the first place that single family homes all be serviced by municipal water. And the way the fire district has attempted to square this, obvious dissonance between some homes in the township being required to have municipal water, i.e. this one, and all of these other approvals that are given without municipal water, is that, well, this one, the Bodish's, is part of a larger development. I guess you can keep saying that as much as they want. The fact of the matter is, it isn't. It isn't there's no HOA. And in fact, in the letter, the fourth paragraph on page 31, the position of the fire districts states that its request for a permit is independent from any larger development or project in the area that would otherwise subject it to FCO review authority. Thus, as proposed by the appellants, the question becomes whether this is a standalone parcel or part of a larger project or development. The fact of the matter is, it is a matter of fact, law, objectivity. It is a standalone parcel. There's no HOA, there's no plat, there's no PUD. They have no control over anyone else in the district. They have no control over any of their neighbors. So to characterize them, the applicant as a developer, to impose a requirement on them that's really a requirement on a quote unquote development that isn't a development, that has no legal standing as a development, that they don't control, they have no ability to even comply with the requirement, is ludicrous. If it's not a standalone parcel, you know, what is it? And this would be a whole lot easier if any of this distinction between developments and single-family dwellings was anywhere in the fire code. And I think nothing speaks to the arbitrary nature of this whole process than the fact that they can cite to nothing. Their attorney wrote this letter, and he signs it. He's a lawyer. On page 31 of the submission, paragraph after paragraph after paragraph of nothing but just narrative discussion, no citation to any authority, any case, any rule, any regulation whatsoever. What is a development? What's that mean? What's the legal definition of development? Nobody knows because it's all made up. It's not part of the code. The fire district has stated that it's drawn a distinction between a quote unquote standalone parcel and situations where there are 3 or more units that are subject to development. Based on what? Where? Where in the fire code does it mention 3 or more parcels? Where are developments singled out? Where are developments defined? Where in Michigan law are they defined? What makes the Bodish's lot that they purchased a development? What gives them authority to comply and extend municipal water at a cost that exceeds the value of their lot? The answer is absolutely nothing. We understand the rationalization that's been made by the fire district, but it doesn't find support anywhere in the fire code, any ordinance, any law, any regulation. And the fact that we can't open up a book and look to see, well, what is a development? When would these requirements be properly imposed and when wouldn't they? How would somebody who's going to purchase a lot be made aware of this? They clearly can't go read it because if it was written down somewhere, Mr. Sluggett would have noted that in his document and he would have signed it and directed us to where this development language is, and it's nowhere. And so ultimately, I'm sure I'm at the end of my 15 minutes or pretty close. That's really what this comes down to, is the fire codes being interpreted to impose this water supply requirement not on every home in the township, but only on homes that the fire district determines are part of a development, yet that's nowhere in there. So there is an extraneous requirement that's being arbitrarily and subjectively applied, and that is contrary to the code and contrary to law. And so for that reason, we are seeking reversal of the fire district's determination and an application of what is a practical matter is the same single family exemption that the district routinely applies to other requests for development of single family homes. Thank you.
Sorry, I was on mute. Thank you, Mr. Phelps. From here, we'll turn it over for the next presentation by the fire code official or their designee for a limit of up to 15 minutes. Greg, I think you're on mute too.
Thank you, Mr. Chair. I'd like to begin. Appreciate the Board of Appeals giving us the opportunity to share supporting documents that verify our position that this is a site, it's a development. And we also show you verification that IFC 1025 does apply. The application that would come up on the screen next would be from the appellant. And the fire code that's being appealed is 102.5, 102.5 in the IFC. The appellant puts in there, or the attorney puts in that down at the bottom of the screen, that 1025 provides no such thing. There's no legal basis for treating this parcel or other parcels resulting from our client's land division as a collective whole. However, we reached out to the International Code Council, who writes the International Fire Code. We have been through this before, so has the Board of Appeals. It is very clear that IFC is intended to be applicable to 1 and 2 family dwellings as confirmed by the International Code Council, and that we have the authority on the exterior of the structure, including but not limited to water supplies. It's right there for you. I want to remind the Board of Appeals that as your fire code official, I'm authorized to enforce provisions of the code, render interpretations, make modifications, rules, procedures. I'm the one who's trained. I'm the one who's experienced. That's my responsibility. So the code provides for a required water supply. It gives a definition in 5071. Code 50751 on the screen shows where a water supply is required. You'll note at the bottom, on-site fire hydrants and mains shall be provided. That is where we reference the hydrant system.
So is this a development, a land split, or not? The fire code does not differentiate between a land split, a PUD, or a subdivision. It treats all of them the same. And as we were discussing, or Mr. Phelps discussed, what is a development? Well, here is the definition right from Merriam-Webster. It's a tract of land that has been made available or usable and or one with houses built on it. Interestingly enough, we did go look at the Michigan Land Division Act just to confirm that there was nothing prohibiting that from what we're doing today. And the Michigan Land Division Act clearly states approval of a division is not a determination that the resulting parcels comply with other ordinances or regulations. So in this case, just because the land splits were approved by then Township Zoning Administrator in 2018 does not mean it complied then nor now with the fire code as adopted by Township Ordinance. Just to give you an overall site view of the parcel we're talking about today, the arrow points to lot 11 or 3487 66th Street, and this is the overall parcel view of the project development. Interestingly enough as well, the Nelderveld, the developer's engineer, actually calls it out as a conceptual overall development plan. So is it a development or not?
So in looking at minutes from the Planning Commission, there are a number of supporting documents that reference that this is a residential development. The minutes are before you. Clearly, the use of residential and recreational purposes is evident. As such, even the applicant answers the question, any such development will be subject to review and approval by the appropriate governing bodies. Further in the minutes, you'll see a quote from Mr. Van Horn that explains that the lots are 1 acre parcels. The use is to water ski on the pond and have residential housing. Mr. Johnson, who attended the Planning Commission, is quoted in the minutes, a natural resource designer and planner. Mr. Johnson reminds the board, Planning Commission, that they are here to talk about removing the sand and that the end goal is to have residential home sites around the ski pond. Further documentation that this is a development and not one standalone lot. And it goes into any future development will be submitted to the township for further fire district review and comment.
Interestingly enough, at that same February Planning Commission meeting, Mr. Zimmerman of the Varnum Law Group, who Mr. Phelps, you heard from earlier this evening, is also a part of, actually stated himself that the end result is not a sand mining operation, but a development for living around a pond. So kind of conflicting information from the same firm there, as it appears. You know, Consumers Energy trenched in underground power down 66th and added 7 transformers. When we reached out to Consumers, they said adding transformers for more than one dwelling, in their mind, they would consider development as well. Communications wiring and pedestals were also installed. So how is it that the developer can spend money to add underground electric and communication cable to 14 lots, but not a fire protection water supply? In discussing potential alternative options with Mr. Van Horn, even as recently as January 12th, he mentions a homeowners agreement or a homeowners association would be responsible for the testing and flushing of his proposed fire pump. I would ask, if there is no development, then why the need for a homeowners association? Mr. Phelps mentioned earlier a couple developments where plan reviews were done with a single family dwelling. In those cases, the fire district was never asked by the township to review those when they were initially developed. However, Mr. Phelps failed to mention or call to attention several other site plan reviews where water supplies were referenced or required. And there's just 7 examples of those on the screen here for you today. To give you an idea of what we're actually talking about tonight, if the developer was to extend a public water main from the closest main on Holland Street to lots 1 through 14, it's estimated at 2,300 feet of water main to cover all of those parcels. If they opted to install water main only to lot 11 or 3487 66th Street at this time, and I'm referring to the hydrant distance from that structure being 400 feet. It is estimated at 800 feet of water main. Mr. Van Horn and Mr. Phelps have both stated that the water main is estimated to cost $750,000 to $1 million. We reached out to the fire district engineer just to determine how they estimate the cost of water main. Based on the calculations they provided us, we came up with a more realistic number of $295,500. So a little less than the $750,000 to $1 million as indicated by the developer and his counsel.
The township's engineer is Prine and Newhoff, and they have developed a water master plan, which is clearly evident on your screen, that shows that a water main is to be provided on both 66th Street and 135th Street. It is not wells, it is not trucking in water, it is a water main. We already had a water main extended up 135th Street from another project. And the idea is to invest in the community for community risk reduction. There are many examples of funded water main by developers. Over 57 developers have installed water main, over 82,000 feet. One of the recent developments was Dunegrass. They put in 5,700 feet of water main, looped the water main, ravines, just miles of water main. So we looked at a similar situated project, Dunegrass in Saugatuck City, about the same amount of houses, 21 homes. So that particular project, they ran a water main, they looped it, put in 5,700 feet. They sprinkled every house and provided hydrants at 600-foot intervals, which is allowed. So we reached out to the developer and asked them, were there any impacts as far as the financial impact? Chris, you can go to the next screen if you could for me.
Right.
And we reached out to the developer as far as, you know, the investment. And it's real clear, this is a quote from him, that considering the magnitude of the development, the investment was easily justified.
So again, we're back to is it a development? Is it a corporation? Is it a single home? So we went onto the Allegan County parcel viewer and searched the parcel records in Allegan County. Lot 11 is owned by Blue Dune LLC, and the other 13 of the 14 lots, including the pond area, are owned by one of the other 3 LLCs on the scene. So collectively, all 14 parcels in the pond are owned by a total of 4 LLCs. Interestingly enough, we then went to the Lara Corporations division to see who owned those LLCs, and Josie Van Horn, now Josie Bodish, is listed as the resident agent or organizer of all 4 of those LLCs. So to us, it certainly has the appearance that Mrs. Bodish and or previously Mrs. Van Horn was not only the owner of all 14 parcels, that now she is the owner of a single one. She was also, on paper, it appears, the developer of all of these parcels. We've heard that the fire district has been accused that we're holding up this project. We just wanted to clarify a little bit of the timeline, that we completed our plan review back on August 21st, and we heard nothing from the developer or their architect or builder until October 15th. At that time, Mr. Van Horn reached out on the Bodish's behalf, and he stated he was frustrated because he was told differently by the former township zoning administrator, and rightly so. However, it is, you know, it's unfortunate he was informed wrong by them. That doesn't mean he complies with ordinances or the fire code as adopted by ordinance. However, he did state at the time that he was interested in working together to get water main and hydrants installed along 66th Street. And to this day, even as recently as I believe last week, we've still been in communication with Mr. Van Horn in an attempt to reach a viable solution for a fire protection water supply. And currently we are waiting on proposed flow calculations for his extending the water main as a dead end down 66th Street and or answering some questions regarding his proposed alternative. Even as recently as December 28th, in this alternative water supply plan that would use an electric fire pump, it is still noted as the 66th Street development. So is it a development or not? Mr. Sluggett?
Okay, can you hear me? No? Yes?
Yes.
Yes.
I'll be quick. I'm not gonna I presume Mr. Phelps referred earlier to the letter that was submitted, signed both by Chief Janik and myself, I think dated January 21. I just wanted to confirm that in fact the board had received that, and that it and the attachments as well as the PowerPoint presented at this evening's meeting all would be, at our request, included as part of the record for the Board of Appeals tonight. Again, I'm not going to belabor what's already been discussed. Let me just hit what, from this layperson's perspective, are the most critical factors. Mr. Phelps appears to make the charge that the fire district or the fire code official is making up out of whole cloth the various policies and regulations that are being applied to his client's property. I don't think that's fair. I think both the letter as well as tonight's PowerPoint make clear that section 102.5 of the code expressly grants to the fire code official the authority to review and needs to approve water supplies for single-family homes, wholly independent of whether this is a development or not. I don't think there's any dispute that 102.5 clearly gives the fire code official that authority. In this case, we also identified section 507 of the IFC, which identifies the need for an approved water supply system. We concede, as we do in the letter, that there's nothing in the code per se that mandates a public water system, but that's not the issue, and that's not what's required. If the applicant wishes to propose an alternative, I think the fire district has repeatedly made clear it would be willing to listen to and consider the merits of an alternative. Thus far, no alternative has been proposed with any meat on the bones, so to speak. In any event, the applicant complains about the fact that we don't have authority, and yet 102.5 and 507 clearly do give the fire district and the fire code official that authority. The fire district then has, over many years, administratively basically adopted a policy to recognize that smaller single-family homes or two homes are not and shouldn't be subject to the same requirements. So then the question becomes this developer exception. And Mr. Phelps, I understand, is complaining that we don't have a definition of what is a development. Well, we do. Administratively, it's been adopted over many, many years and applied uniformly over many, many years. And that's valid, as the fire code official is authorized and the fire district is authorized to do. Even were that not the case, I don't see how getting rid of the development gets you around or gets the applicant around the requirement of 102.5, which is, okay, fine, we don't have a development. Even, I don't think that's the case, but let's suppose for argument purposes that we don't have a development. Okay, fine, then under 102.5, you still need an approved water supply system and you haven't submitted one. That's the end of the story. That's the end of the debate. You can't have it both ways. This isn't, I think one of the fundamental problems here is this isn't either or. The applicant is proposing that it's either a single lot or it's a development. Well, no, it can be both. It's a single lot that is part of, and has been for several years now, part of a larger development. Proposed as a larger development, sold to the Saugatuck Township Planning Commission as a larger development. There's no dispute about that. This particular parcel is included in the special land use application that was submitted to the Planning Commission. The purpose of which was to remove sand so that a common pond could be utilized by all these lots. That's a development. Nothing in the law requires us to ignore reality.
Just to break in here, I think we have about one minute left.
Nope, that's fine. I'm wrapping up. I would just encourage the board not to be misled into thinking that this particular lot cannot be both a single lot. I don't think anybody can argue that it's a lot, but it's also part of a development. And the fire district and the fire code officials' obligation and duty under the fire code is to look at the larger picture, to look at how this development will be able to handle fires or other emergencies. As, and this is the last thing I'll add, as was recognized by the applicant, by the applicant's predecessor, as well as the developer's attorney and planning consultant, all of whom acknowledged that there would have to be at some point a review of the development for fire code purposes. So with that, I'd be glad to answer any questions.
Back to you, Chief.
Just wrapping it up, Aaron, we just want to state our position that the fire district is not misapplied. There has not been an acceptable equivalent method of protection provided or approved. 105 and 507 fully apply. Thank you.
Thank you. So going back to the agenda, I think from here, we'll allow presentation by, sorry, I'm getting a major echo. I think we'll allow time for presentation by anyone else in the meeting who would like to present for a limit of 3 minutes each. So a way to do this would be either within Zoom, use the raise hand function, or unmute and start. So Chris, do you need to unmute people, or do they have the ability to do that themselves?
I believe they should have the ability to do that themselves.
Okay.
This is Aaron Phelps. Yeah, this is Aaron Phelps. I'd like an opportunity to respond, whether you want to call it the 3 minutes or otherwise.
Actually, you've already given your presentation, so unless there are questions from the board for further clarification, then we will not allow that. I'm sorry. But are there other parties who would like to present?
Well, it is an interesting process. You raise a bunch of falsehoods and then you won't let us respond to them.
That's the process through which the appeals meetings work.
That is the process, it appears.
Are there other parties who would like to present? No? Okay. With that, I will entertain a motion to close, or I'm sorry, I'll start with discussion among the board. Eric, would you like to go first?
No, no, I'm just trying to take it all in. You know, you look at this, and as far as I'm concerned, it does look like, I mean, it looks like a development. There's 14 lots on one side of the pond. What happens on the other side of the pond? You know, it's tough to look at this. I feel for the Bodishes. If this was in another area, not part of another bunch of lots, they would be building already. So I get that. One of the questions I had for, I don't know if we have any representation from the township here other than myself, is there any plan by the township to extend that water main in the near future to continue to finish the loop around 66 to 135th, which would be the ideal situation for everyone involved, at a cost obviously to township residents, which I am one, but there is a new well over there that was donated, and we will be having that line run eventually. I just don't know when and if it is in the plan. And the other question I had maybe for you guys talked about another source of water. Has, you know, I think you answered this, but has the landowner, I don't want to call him developer, but reached out with an alternative plan here? So that's just some of the questions I have. I don't know if I can get those answered. but it sure looks like a development to me.
All right, Jane, any thoughts from you?
Well, it looks like a development. It acts like a development. There's 14 lots in a row that have the same sign. There's a real estate office on site. All of the lots are for sale by the same person, by the same real estate company. I don't know how you can call this not a development. It's been sold to the township, and I've watched this over the years as a development. Why would you dig a ski pond that's 5 acres, 10 acres, whatever it is, and plan to put residential houses around it and say it's not a development at the end of the process? It's been sold as a development for years. I really don't understand why you wouldn't want the fire department to have the best chance possible to put out a fire. You put in electric, you put in the best of Wi-Fi, you put in the best of everything, but are you going to get fire insurance on these properties? Because it doesn't sound like they're going to burn ever, because there's no water supply for the fact that they might. I think we have to start calling a spade in this community. The last Board of Appeals, that wasn't a development either. That was 3 or 4 toy barns. If you drive by that development, you'll find out it's more than 3 or 4 toy barns. And we really need to start continuing infrastructure in the township. And that's something that the developer, and I'm sorry, I got to call him a developer. I don't know what else you would call Mr. Van Horn. Would work out with the township as to how the infrastructure is going to be extended. And I just don't understand any of this. This is a development. This has been sold as a development for years, and it clearly comes under IFC standards. That's all I got.
All right. You know, Chris, or sorry, Eric, thinking about your comments, which basically are asking, are there other ways of getting the water supply, whether that's through the township or anything that the landowner has proposed? And, you know, I think that certainly, if it hasn't been already, I think it has been. If it hasn't been explored, I think it could be explored after this, but that isn't sort of, in my mind at least, dependent on, or, you know, our decision is not dependent on answering those questions. And certainly the township could decide to extend the water main at taxpayers' expense, no matter how we rule, really. You know, but my thoughts as I've read through this over the last week or so, as well as read through the codes and the ordinances, is one, that these codes and ordinances are not perfect. You know, they are written by people. They don't necessarily aren't necessarily written together. So there are times where it's certainly imperfect. But the first thing I'd like to say is, you know, I do feel really terrible for the property owners, the Bodishes, and that building or buying a home is one of the most stressful events in life. And I'm sure that these appeals and challenges really magnify that stress, and no one wants to be in that situation. But based on review of the appeal materials, the applicable codes, you know, I wrote up my thoughts, and I apologize in advance that they're kind of long, but it's how I had to do it. To me, reviewing the materials, it was clear from the start and in multiple ways that the intention of the developer was to split land for residential purposes, to mine sand, to create a pond for residential purposes, and that there would be multiple parcels for residential homes. And as evidenced through the paper trail that was included in our packet, a lot of attention and time was spent on that sand mining operation, or that sand operation, but apparently no time at all was spent on the development, the residential development. But as noted in a February 2020 email, I think it was, the developer noted that they would apply for appropriate permits for the residential development. The developer also acknowledged in a separate communication that any such residential development would be subject to review and approval of the appropriate governing bodies, and the fire district is one of those governing bodies. The applicant in their application and tonight argued that this isn't actually a development because it's not the product of a plat or subdivision, and each parcel will be developed by the owner of that parcel. I don't believe that defines a development, and as the fire officials tonight asserted, the IFC doesn't actually define or limit a development to a subdivision, a plat, or a PUD. And I think common understanding of a development does include the scenario that is in this case, a landowner who divides their land into multiple adjacent parcels for the purpose of selling those parcels for residential purposes. Whether or not the homes on those parcels are also built by that landowner or the representative is irrelevant. The applicant argues that IFC section 102.5 makes no mention of developments, and that's true, and that the word development does not appear in that section. But the official commentary from IFC for that section does clarify when the code should be applied. And to quote from that commentary, although the International Residential Code regulates the construction of detached 1 and 2 family dwellings and townhouse structures, it does not regulate the design and construction of emergency access to and community fire protection for residential developments containing such dwelling structures. Accordingly, where the International Fire Code is adopted, the design, construction, regulation, and maintenance of fire apparatus access roads for servicing such residential developments must comply with the provisions of Section 503, and if adopted, Appendix D. The important part in this commentary is this sentence, that also the design, construction, regulation, and maintenance of fire protection water supplies for servicing such residential developments must comply with the provisions of Section 507. And when you refer to that Section 507, the very first sentence says, an approved water supply capable of supplying the required flow for fire protection shall be provided to premises upon which facilities, buildings, or portions of buildings are hereafter constructed. Which to me, reading all these things together makes clear that residential developments, which are not limited to PUDs or subdivisions or plats, need an approved water supply for fire protection. And that code, which makes those requirements, has indeed been adopted by the township as their code. As far as I'm aware, there is not an official description. As Mr. Phelps did point out, there's not an official description in any of these codes or ordinances that describes how many homes are required to be considered a residential development, as noted in the IFC commentary. And I do think that is a deficiency in the ordinances for the township that should be addressed and clarified. However, over the course of many years, the fire district has consistently applied a definition of 3 or more houses that trigger those requirements for residential developments, which is why in some of the approvals brought forth by the applicant, it says single family dwelling exemption, meaning that the home is not part of a development of 3 or more homes. So based on these findings, I think it's clear, at least to me, that the fire code official properly applied the International Fire Code as it's been adopted by the township. The question I do have, though, is why were these requirements apparently never discussed and set forth with the developer? I think there are 2 potential factors. One, the previous zoning administrator failed in his responsibility to communicate those requirements in 2018, and also, unfortunately, miscommunicated that fire district reviews only apply to emergency access as it relates to driveway length, which is simply just not true. And I look forward to the day when we're no longer dealing with the ramifications of that particular administrator's decisions. The second factor, which the appellant points out, is that township ordinances do not explicitly mention these requirements for residential developments unless they are planned unit development or a subdivision. The township does have some helpful documents on the website as it relates to site plans or building permits, but there isn't anything in those documents that mentions requirements for residential developments that aren't PUDs or subdivisions. And so while water supply requirements are indeed in place based on the fire code that the township has officially adopted, I think it certainly can be easy for developers to miss, as well as the planning commission in the township and the zoning administrator. So I'd strongly recommend that the township update ordinances and other documents to explicitly call out requirements for residential developments that aren't PUDs or subdivisions. It also would be a good opportunity to codify what defines such a development rather than relying on informal agreements that have been in place for years. So I sympathize with the property owners as well as the developer, and I assume positive intent that they tried to follow all the codes and ordinances and to work with the governing bodies as appropriate. I think the failure is on the township in properly communicating requirements based on the codes that they've actually and officially adopted. However, it is not the responsibility of the fire district to compensate for or fix mistakes of the township or the other municipalities it serves. And this Board of Appeals also has no authority to waive requirements that are dictated by the fire code. The fire district responsibility is to follow codes as adopted to ensure adequate protection for residents and businesses in our community. And I think the facts find that they've done that, and the fire district's decision should be upheld. Those were all my comments. Thank you for bearing with it. Any other thoughts, comments from Jane or Eric?
No, well spoken, well said, Aaron. I appreciate all the hard work you put into that.
Sure.
Thank you, Aaron. I'd like to move that we move out of this public hearing and go into a open session for action by the board.
Is there a second for that motion to close the hearing?
I'll support.
Okay, Chris, can we please get a roll call vote?
Chris?
Works better when I unmute too. Sorry about that. Verplank,
Yes.
Beckman,
Yes.
Van Miller.
Yes.
All right, 3-0 to close the hearing.
All right, so next is action by the board. Would anyone like to make a motion? I can if you guys don't want to.
I'll make a motion that we deny the appeal and wait for a water supply.
I'll support.
Mr. Chairman, this is Jeff.
Yes, go ahead.
Can I suggest to the maker of the motion that she identify the reasons for proposed denial of the appeal, even if it's only to incorporate the comments and record that's been presented at tonight's hearing?
Okay, I'll include, according to the record of the comments made tonight, we deny this appeal and move forward with the motion.
Does that work?
I'll
Jeff,
support.
Does that work, Jeff?
Yeah, what I'm hearing you say is that the decision, regardless of what it is tonight, will be, or if this motion's adopted, that it will be based on the record that's been presented in total at this evening's hearing. Is that correct?
That's correct.
Okay, thank you.
Chris Mantles, would you like to read how that, how you captured that motion?
Yes, motion by Verplank to deny the appeal based on the comments on record tonight at this evening's hearing, and a second by Beckman. Does that sound right?
Sounds good to me. All right, I can get a roll call, please, or I should stop and say any further discussion on that motion? No. Okay, Chris, can we please get a roll call vote on that motion?
Yes, Verplank,
Yes.
Beckman,
Yes.
and Miller.
Yes.
All right, motion passes 3-0.
Thank you. So moving into agenda item 7, public comment, limit of 3 minutes each. Please, if you would like to share public comment, please use the raise hand button in Zoom, or if you're on the phone, enter *9 and you'll be recognized and unmuted to speak in the order received. Are there any public comments? Going once, going twice. All right, moving into agenda item 8. Any comments from the Board of Appeals members?
Yeah, no, I will. Just in general, I really feel for the Bodishes here, and I wish we could come up with a compromise like the last 2 appeals that we've worked through. Both times the appeal, there was a compromise and both worked out for the best of the community. And I'm just hoping that maybe something here will happen also. So if Greg, can communicate with Mr. Van Horn and hopefully come up with something, and to the township, like I said, I don't know where we are in the township as far as extending that water main, but it sure would make sense to do it sooner than later. Thank you.
Yeah, thank you. I'll also just reiterate that my sympathies and thoughts are really with the owners, because it is a bad spot for them to be in, and really this should have been resolved a couple of years ago when the development was in planning mode. And Jane, anything you'd want to add?
Well, I just hope that for the landowners, they come up with the best firefighting capabilities possible. I think everybody deserves to have those.
All right. With that, can I get a motion to adjourn?
I move we adjourn.
Support.
All right. Do we need a roll call vote to adjourn?
Yes.
Okay,
Yes.
roll call to adjourn, please.
Yes, sir. So a motion by Verplank, seconded by Beckman to adjourn at 6:52 p.m. Verplank,
Yes.
Beckman,
Yes.
and Miller.
Yes.
That'll be passes 3-0, sir.
All right.
Thank you.
With that, thank you all very much for your time, and have a good night.
Thanks, Aaron.
Thank you.
Good night.
Thank you.